Layback Law with your favorite lawyers from around the interwebs.
No. Piers Morgan is doing the hide my boner lean. That's what he's doing. Look at him.
I think this is actually the first time that a billionaire cut safety standards, and it was the billionaire themselves that died.
And that's what made Poliere's, I don't even know how to pronounce this guy's name.
Poliere.
I'm board certified criminal trial law in Florida. I'm your man. Of course, you have to compensate me.
Discussing the most pressing of topics every Friday at noon Eastern Time.
I did this way before him. I had the big brain panel before EricHunley even existed.
All right. Good morning.
Nice.
Good afternoon. I'm Ian Corzine, guest hosting for EricHunley today in Layback Law. We're really privileged to have MLS and also Michael Boyer on the live stream today. We put together, because we wanted to have some organization, a kind of let's see, put it this way, an agenda for today, so you can get a preview and also kind of estimate when to join the live broadcast. The first topic that we're going to talk about is OJ stories. I'm sure we all have OJ stories. Of course, OJ Simpson has passed away yesterday at 76 of reportedly some sort of cancer. I'll just begin and just say that I was actively involved in government and becoming a lawyer back during that time. That was one of the main reasons why I even got involved, was watching the day-to-day OJ Simpson trial for the murders of Nicole Brown Simpson and Ronald Goldman. It's foundational. One of the reasons why I wanted to be a lawyer was that so I could go to LA Superior Court and be a lawyer like Johnny Cochran. And I will tell you this, I ended up doing that. And I ended up actually being in court with Johnny Cochran. And I'll be real brief on my story. But one time, about 19, I think it was 2001 or so, I'm sitting there in LA Superior Court, and we are getting wind that the opposing counsel is being replaced. And we're like, we don't know who that is. And in comes Johnny Cochran walking in the courtroom. And in LA Superior Court, it sucks, especially back then. It was old, it was small. He walks in, he's on a cell phone as the judge is presiding. He's talking, and the judge looks at him and kind of like puts a little bit of furrowed brow. And then Johnny Cochran goes, 1 minute, judge. Finishes the phone call in open court, and then puts the phone down, and then proceeds to argue in favor of his new client. Maybe needless to say, the case settled probably within 3 days after Johnny Cochran got in the case. He was brought on for lump sum payments of hundreds of thousands of dollars just to end cases, because his mere presence meant that one, there was going to be public attention, and that two, he was an amazing lawyer. So that's my Johnny Cochran story. That's my OJ story. Do you guys have any stories, MLS?
I don't have any stories specifically about that, although I love how everything surrounding the OJ Simpson trial has seeped into popular culture. Like there's a flashback on Scrubs to when the verdict came out, and JD and Kurt or Turk are, they're on opposite sides. The reference to Johnny Cochran showing up and settling cases was in Arrested Development and all these, but there's just so much references to everything, or even the Seinfeld trope with Kramer's lawyer,
Absolutely.
Everyone's trying to come up with a tagline too now, or not everyone, but a lot of times they do. And it's taught in law school. We had orientation in law school, and the clip that they played for us was Johnny Cochran saying, "If the glove don't fit, you must acquit." And then from then on, everyone's like, "Ooh, we got to come up with a catchy phrase for our closing arguments and stuff." It changed the way people perceived defense attorneys for a bit. It changed the way police investigated crimes for a bit. It changed the way prosecutors presented their trials for a bit. And I keep saying for a bit because I've been watching Jodi Arias' trial and some older trials that came after. We get like a 15-year span, and then we get Jodi Arias and those sort of sensational cases. And then we get another sort of like 15 years down the road. And I feel like they're back to their old shenanigans, what they were doing in the OJ days, as far as the state and the prosecutors and stuff. But it was definitely a seminal case that changed police and prosecutions around the country. So
it changed media. I mean, I think it was the original live stream of court proceedings. Before then, it was kind of like, okay, there's courts going on. People are being prosecuted. People are going to jail, whatever. This was this basically created an industry which a lot of us lawyers are in, which is live streaming and doing commentary. Back then, there weren't necessarily most of it was news anchors, but they were doing commentary as the proceeding was going on. And one of the amazing things back then too was, there weren't that many channels. And if you wanted to, if you're bored at 1 p.m., I got back from law school and I just want to chill, I just turned on the TV and I knew the OJ Simpson trial would be going on. So you're so right. It was I guess it was the trial of the century in so many ways. Michael, do you have any thoughts on it?
I was 5 years old when all this was going down. So my perspective on this isn't really one of a practicing lawyer, or because I didn't know I wanted to be a lawyer until I was actually applying to law school, 4th year of my undergrad. So OJ was ubiquitous in popular culture, right? As I was in my formative years, the OJ trial, Johnny Cochran, beat the case. If the glove doesn't fit, you must acquit. That whole thing all of that was circulated in popular culture. And it was always known that it was a divisive issue, right? And especially within the Black community and the hip hop community. I talked about this morning on my stream with Norm, specifically that even if there were those that believed genuinely that OJ was innocent, right? And there was almost a perspective adopted in mass that it didn't matter, right? That he beat the case, and that any sins or transgressions that we would never know about, or that he would never be found guilty of, were all good based on past history in the U.S., right? It was a triumph over the man, and that trial was something of a seminal moment in American culture that changed a lot. And I, like I said, I grew up within that culture, and just this understanding that irrespective of the underlying facts and circumstances, irrespective of sort of the gamesmanship on both sides, prosecution, defense, whether it was, changing things for the jury walkthrough of the home, introduction of evidence, any of the law enforcement officers that were sort of cross-examined and trying to get sort of their perspective, or maybe what their intent is in prosecuting OJ. OJ was a handsome guy, wildly successful guy, very relevant in a professional sports context. And so there were a lot of people rooting for him anyway. But I think that the Rodney King stuff was a pretext that could not be ignored. Right.
Mm-hmm.
And the 90s were a time in America unlike any other. So I think, from my perspective, this was something, OJ popping up in the last few years is probably the most surprising thing to me out of anything that happened. Right. His sort of rebirth into social media and popping up on Twitter, and his whole, just saying, everybody saw, just saying, I'm just saying, right? That kind of stuff. That was always odd to me, right? He kind of leaned into this, he had this magnetism about him, good or bad. He knew how to play that. And then, of course, his involvement with the Kardashian family, right? Bruce, now and Jenner, right? He is an enigmatic figure, depending on how you're looking at him and his situation. It's hard to really wrap one's mind around what OJ Simpson is as a man. Depending on the type of conversation you're having, you're either talking about, his 2,000-yard season or whatever, whatever it may be. It's tough for me to give a perspective from a legal context, but I can certainly tell you from a young person growing up in American culture that he was an iconic figure, notorious in some circles, and then sort of heroic in others.
And, he was also coy. I was going to mention, he was also coy. I think before then, you didn't play fast and loose with law enforcement or the powers that be. We'll talk about a little bit more MLS, but of course, he got a civil verdict against him for $33 million that he owed portions of to the Goldman and the Brown family. And then yet, because again, he was not financially, sound, he put out this book which said, "If I did it." But if you remember, the font size on "if" was so small that it looked like it said, "I did it." He was effing with us.
Oh, okay. Hang on. Well, first, with regard to the book, his book was "If I Did It," and "if" was the same size. Yeah. Then the Goldman family got the rights to the book, and they changed it and put the "if" really small inside the "I." So I do want to correct you on that one. But what I was going to say is, from a legal perspective, like I grew up I was 14, 15 when the verdict came out, and I kind of grew up. Oh, OJ did it. Of course he did it. He beat the criminal rap, but he got on the civil rap, and he always did it. But now, as an attorney, and I'm looking back at this, and you're re-examining this outside of the media coverage and stuff. I know Legal Vices has been replaying it for a while, and other things. What did they really have other than he might have beat her up in the past and some shoe footprints? I mean, because the airplane flights, his trip. A bunch of other stuff. The DNA was questionable at best, but they didn't really have a lot of evidence to tie him to, other than he's a bad guy that's beat her up in the past, therefore he must have done this. It's just interesting.
Yeah, it is interesting. And we had a guy, Mark Furman, who was one of the investigative officers, who actually during the trial testimony claimed the fifth, with the implication being that he was being illegal with framing someone that probably was liable, criminally liable for these murders. Weird stuff. I mean, and that stuff is stuff that you couldn't even think about as, writing a fictional account. It's one of those things that just happens in life where you're, what the hell? There were twists and there were turns. It was, for the most part, being a TV watching audience, I remember everybody's like, gosh, this guy's going to be convicted. And then yet, if you were really paying attention, you saw that there were so many holes. You analyzed the jury panel, and you were able to come up, especially with the time period. This is after the Rodney King beating, probably, I think it's 2 years or so after that. So there was lots of sentiment. There was a lot of political implications. It truly was the trial of the century. There's no question.
Yeah, and I think Norm will be joining us here in a few minutes, but Ian, I was sharing with you before the stream started that this morning when we were talking about it, we sort of resurfaced part of the conversation that he and I had. God, this has been about 3 years ago, but F. Lee Bailey and his involvement in on the defense team for OJ Simpson, one of the names that doesn't really get mentioned because of sort of the largeness of Johnny Cochran, but
Yes.
Norm interviewed F. Lee Bailey just shortly before he passed away in 2021, and some really interesting stuff came out of that. But F. Lee Bailey lived his entire life with a genuine belief that OJ Simpson was indeed not guilty, right? That he was innocent of the underlying crimes. And so I definitely, if we put a pin in this and Norm joins, I certainly think that the audience would benefit from a lot of what Norm has to offer in that respect.
I'll be happy to hear more. There's just one other story that came out, I think this morning, and that was that OJ Simpson on his deathbed in Las Vegas, Nevada, had not only his children and family members visit, but also friends. I think it was 30 to 50 people visited it because he knew he was passing. And he required even his kids to sign NDAs. Dave, do you have any idea what that was about?
He had him sign an NDA. Oh, yeah, I heard rumors that he might have had a deathbed confession. To clear his mind, maybe he wants to express his whatever, get things off of his chest.
Yes.
But he doesn't want people talking about it. That would be the only basis that I could conclude.
Well, the other one too, guys, you got to remember, there's still a judgment outstanding owed to the Goldmans and the Brown family. And my thought was, being the kind of civil lawyer that I am, is that he wanted the ability to let his family and maybe friends know where the money was.
That could be.
It was very interesting. You'll remember way back when he moved to Florida, it was based upon the homestead exemption. In Florida, you can buy a house for cash, and all the equity in that house is protected against creditors. So it depends. There's limits, but the bottom line, at his time, I think he spent $575,000 on a house. But back then, that was a lot of money, especially for a Florida house. It was on a golf course, all these different things, and he was able to protect that money for a long time. He also had a $25,000 a month pension from the NFL that was protected. And this is not widely reported, but he fully funded all the retirement accounts he possibly could before he was convicted, understanding that at some point in time, there may be a civil judgment relating to the criminal judgment, and he'd need to protect it. So my thought is, and also the other thing is, the guy, like I think Michael was saying, was super charismatic. And so as a result, he made money on the side. There were golf bets, there was signed autograph memorabilia.
Wasn't that the whole deal? Wasn't that the whole deal with him stealing the memorabilia back because he was basically using that money to live off of. Essentially, that was the idea behind it, right? That's why he
Yes.
needed to go after and get it. Although there is no right to self-help in those situations.
Yes.
Everyone thought he was like destitute. And that was the first time I had heard about him since like really the civil trial. I didn't know what he was doing. And then all of a sudden he's back in the news, charged again.
Yeah.
But
I mean, it occurred to me that he was a pretty intelligent guy. I mean, again, I think back to him popping up on Twitter, and that's the first time in my life that I'd ever heard OJ speak, present himself publicly, and what a testament to what social media has done for being independently networked and going direct to those that want to hear what you have to say. There's no doubt in my mind that he's savvy, he's sophisticated. It's not as if he's working with little between the ears. I think that he probably had ways. And of course, being tied into the Kardashian dynasty, right, before it became what we know it to be today. Just because you don't have obvious public ways of making money that people can see doesn't mean that you're not able to do for yourself. I think he was an ad consultant as well, right? So I really know very little about sort of subject matter expertise outside of football, and then his notoriety with his trial. But suffice it to say that it's not a stretch to believe that OJ was far capable off of the gridiron in a way that was meaningful to those in his personal life.
Yeah. Well, Michael, we're going to reserve a little more time for when Norm comes on to talk more about OJ, because we probably could go the whole hour and a half on OJ. There's so many, curving roads relating to the case. But I want to talk to something a little bit less serious. No, I'm just kidding. Let's move to the Arizona abortion ban that just took place. I think it was a couple days ago. Dave, do you have any videos on that?
Do I have any videos? No.
Yeah.
No, I don't. Although what I'm going to say about this is that this is poor planning by the Arizona legislator, right?
Okay.
So this law exists, and you know that Roe v. Wade was overturned, and so that at some point there's going to be a challenge that's going to say, "Hey, is this old law going to be enforceable?" And you shouldn't wait until the Supreme Court says, "Well, yes, it's still a statute on the books." They should have been a little bit more prepared.
Yeah,
this is an interesting. My thoughts. It's just poor.
This is an interesting case to me because they're making a big deal about it politically. They're saying, "Oh gosh, this is bad for Trump going in to be in the presidential election because there's one state that is, basically gone back into the 1800s to revive a law that outlaws basically out and out abortion." The real question, though, is what the court did. And the court did this interesting thing. It made the ruling that it was constitutional, according to Arizona, to have basically a full ban on abortion, except for a situation where it's endangering the mother's life. But they also put a stay on it for, I believe, 14 days or so. Let me clear that. 14 days or so, because they wanted to be able to allow the petitioners in this case to be able to petition this for an appeal to a higher court, to the federal courts. And my question came about is, what would be the grounds for this? One of the things that in law school I came out of it not understanding, are there any guardrails, any federal constitutional guardrails for abortion in America? Once Roe v. Wade was out, and therefore kind of federal control over the issue went to the states, is there anything that says that this Arizona law is unconstitutional? And the answer is, my gosh, I couldn't find any. I mean, there's an issue concerning equal protection, potentially. It may be segmenting a portion out in society, but I did not. I mean, what I'm trying to say is this law may just be on the books unless the Arizona voters vote to repeal it.
Well, or if legislature gets its act together and actually passes a law. So what we talked about this morning, my perspective on this is that, Roe dates back to 73. Is that right?
Yes.
So we've had about 50 years of Roe v. Wade being the law of the land with respect to abortion.
Correct.
And the issue therewith is that states are free to enshrine in their state constitutions law which the Supreme Court makes at least reasonably clear through their decisions. The question for everybody watching this stream is, why did no state legislatures, namely in this case Arizona, enshrine Roe v. Wade in some meaningful way in their state constitution at some point between the 50 years between the time Roe v. Wade came down as law or as binding precedent, I'll say, and when the Dobbs decision came down. I think that's the threshold question that everybody should be asking themselves, because it doesn't matter that, your state can look at Roe v. Wade and figure out a way. If there is a motive, right, is that if there is some inspiration at the legislative level in your state to do that. And I think that anybody that is who is just put off by the Dobbs decision or feels as though, we have regressed as a country, well, that's why we have 3 co-equal branches of government, right? And in the judicial branch is responsible principally for what? Saying what the law is, not making it. But it appears as though American culture and principally Congress for the last 50 years has been complacent. And I'm cynical about this. I think that this is a very easy issue on both sides of the partisan line to fundraise off of, right? Because of that, there was no motive to actually do away with the problem, right? Because there was an infinite amount of money to be raised, counter signaling against the other side, pro-life versus pro-choice, as it were, right? So I think that's the main issue. I sent you, Ian, a link here in our private chat to the order of the Arizona Supreme Court, and it does, it may be worthwhile throwing that into the public chat as well. People can read the ruling. It's fairly long, and the court is not aloof, I'll say. The court is very self-aware as to how important of an issue that this is and what they're ruling on. Ultimately, there were lawsuits predating the Roe v. Wade decision about the right to abortion or enshrining abortion, and the laws that were passed in Arizona were under scrutiny, and they were being litigated. At the time that Roe v. Wade occurred, it appears as though the laws that were on the books just sort of languished there. And when the Dobbs decision came down, that's when those original cases became ripe again to adjudicate. And the principal question for the court was whether the 1864 law, which said that abortion was totally unlawful, with the lone exception being to save the life of the mother, right? Whether the laws that were passed subsequent to that were in conflict, or if there was jurisdiction for those laws, whatever it may have been. And the court found from a constitutional perspective, no, those later issued laws were not in conformity with the Arizona state constitution, did not pass constitutional scrutiny, and therefore were invalid. And therefore the only law left on the books was the original 1864 law outlawing abortion. And therefore the conclusion of the court, and the mandate of the court was to say, hey, look, we're not moralizing. We're not taking, we're clear. We're not moralizing here. We're not taking a side. We are simply telling legislature it is time to do your job.
Yeah. And that's what I think one of the fundamental issues is that people don't understand sort of the hierarchy of law and why this decision had to be this way. Because think of the alternative. If the court decides that a statute passed by the legislator, however long ago, just all of a sudden doesn't apply anymore, then that grants the court the ability to just say any statute that the legislator passed, if we decide that it just shouldn't exist, then we're not going to allow it to exist. But that's not the role of the court. The court is there to say, all right, here are the hierarchies. We have the Constitution, then statute, then common law. And the statute controls over common law. And when you get that case dismissed, that Roe v. Wade case gets overturned, then we have to fall back to these statutes. That's just the way the law works. And you need to change the statutes. And I think it was a great point that you made, that this was never codified. We have I have a old,
right. I mean, it's like that's what's so crazy about this, is that maybe Arizona is embattled for various other reasons dealing with the election, but Donald Trump and Carrie Lake, in their respective rights on the political right, have come out with very pragmatic views about this issue, right? So in terms of consequences to the election, this isn't necessarily a losing issue for Republicans now, because the front runners of the Republican Party have come out with a very pragmatic, more centrist, contemporarily moderate view on the issue, one that actually appeals to the widest possible demographic of voters. And Carrie Lake, I believe, has come out in support of a 15-week threshold there, right?
Well, I mean, at this point, everyone in the reasonable discussion What we're talking about is the life of the mother and the life of the child, and there's a line somewhere in there where one right trumps the other one, right? That's what we're talking about. At some point, there's a line, whether it's 15 weeks or whatever. We're talking about where we're putting that line. That's not for the courts to decide. The court is sitting there saying there's a statute. The statute's enforceable. It's not on its face unconstitutional. And until the legislator does something and establishes some sort of line or other rule, it is what it is. You guys got to step up. Hey, Joe.
Until they do something to represent their constituents. Do we have like an applause?
Sound effect.
So the chat has been waiting for your arrival.
How are you,
Joe?
Hey,
So what's your position on abortion right now?
It's not at all a federal issue.
Yeah.
There you go.
It's not at all. And that's actually the healthiest way to look at it, because one of the things that makes our country fascinating and unique is that different pockets of this country have very different values as to what is moral and what is immoral. And that is where the democratic element to our democratic republic plays a very vital function of in a ideal situation, which really should be everywhere, that, or in most moral issues, that the local populace decides, okay, this is what we as a majority believe is the proper position on issue A, B, C, and D, and abortion certainly would be one of those issues. And that's why I don't think that the law should be the same in California as it would be in Oklahoma or even in New York, because different cultures have different perspectives, and that's the beauty of what America is.
But Joe, what do you think about this?
My personal take is, yeah. I'm personally pro-life, other than a situation where the life or limb of the mother is imperiled, in which case I would say that her health takes complete precedence. And I don't mean like the discomfort of childbirth. Everyone deals with that. But I mean any sort of long-term any sort of genuine potential long-term issue for her health, that fetus is basically that she's self-defense from the fetus. The fetus is coming to attack her, and accordingly that she has a right to protect herself from that, and we should help her protect herself.
And Joe, but taking you back to the initial discussion you had, is there a value though to consistent law across the country? I mean, what if the ability to drive a car in America was up to the states? So in California, you can't drive a car. In Arizona, you can. Is there any value to adopting a federal standard for consistency, and then allow the states to make modifications as they see fit?
So I think that there are few areas that is true, and they tend to be covered by and large by our Bill of Rights as to what areas must be held universally. And so yeah, I mean there's logic to your question. I think it's a very important question for people to consider within themselves. As and there are certain added rights which are not necessarily enumerated in the Bill of Rights, as reflected in the 9th Amendment, which says this is not a dispositive list and exclusive of anything else, but that there are other rights which are universal. We just can't really think of them right now. We certainly don't want to limit ourselves in saying that there are no more, that people are not going to recognize other rights in the future. So yeah, there are other rights. I think we should be very cautious, very, very cautious, before we try attaching that universal right to anything. One case that I actually thought of when I was discussing like 4 or 5 months ago is something that should be a universal right, and not the same level as our First Amendment rights. But we talk about the right to speak, but then there's the right to hear, meaning the right to access speech. So you can look at that as a fundamental right, because what is freedom of speech if you're going to stop everyone, let's say in the example of the state of Montana, from hearing TikTok, right? So from being able to access that. So I don't think it should be the same level, because it's fundamental to us. We need to be able to express ourselves, rather than we need to be able to have access to whatever someone else is expressing. But to say that there shouldn't be some level of protection there, that would be attached to that, I definitely think that should be, certainly I wouldn't call it strict scrutiny, but maybe intermediate scrutiny, some sort of lower level, so we make sure that people's rights to hear are not being wrongfully impeded. And that's not enumerated anywhere in the Bill of Rights or anywhere in the Constitution. So
at the risk of making a meaningless comparison, but I think it may be helpful, at least for this. I practice in the beverage alcohol industry, and so I think first of the 21st Amendment, right, where federal government left it to the states to decide, right? And what happens state to state is what we know now is the 3-tier system, and there is intense variability from state to state in terms of how the 3-tier system operates, from supplier to wholesaler to retailer, in terms of how products make their way to the market. And there is a federal body known as the TTB, the Alcohol and Tobacco Tax and Trade Bureau, which regulates, everything to do with the manufacture of alcohol, blah 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 blah. But that developed later. I think what we may be looking at here is an opportunity for the federal government, Congress, to actually enshrine something akin to, hey, states will decide, and then over time there will be some sort of bureaucratic bloat that forms itself into an administrative agency responsible for the administration of these sorts of things at the state level. But
would that, Michael, would that help? States will decide as a federal law. Isn't the only potential possibility is enshrinement of a right to abortion and then modifications thereof? Or you, otherwise we don't need a law. Otherwise we have a situation where
I want to push back on that overarching thing. I think this is something that it's drilled into us at birth, that we sort of accept without ever questioning. And I apologize for interrupting, Ian, or jumping in.
No, it's totally fine.
I sort of look at, but as I got older, I sort of learned to look at our states as those are sovereign entities. Look at those as 50 separate countries that are all associated with each other with certain overarching things that were like, these are our common cores, these are our common beliefs, these are things that we hold inviolate. And those areas are where federal civil rights or issues of basic humanity and dignity, that we say, hey, look, state of California, you decide to have 1 week purge every week. That's not constitutional, because those are certain things that we as an association have agreed are things that are boundaries that cannot be crossed. But beyond that, ultimately, that we look at every state, that's your own unique sovereign kingdom, and we need to have, you can't restrict other kingdoms, you can't restrict other states from interstate crossing, we can't restrict them in the ways that are going to be violative of them, and that's why you need to have federal court systems to sort of sort that out. But overarching, that as little as possible should be dictated from our federal government, because we are 50 sovereign states. It's been lost ever since the New Deal, ever since FDR tried cramming through the New Deal, and everything just became all a matter of federal issue, and they can start using their money as daddy paying off states to do what they want, or withholding money.
Federal blackmail.
Yeah,
what it
is literally federal blackmail. It's federal extortion, because some of these states are desperately reliant on those monies, and say, okay, we're going to have to bend the knee to the federal government again. But that's where the federal government takes on an aspect, a tyrannical aspect, because they're not supposed to be doing that. They're not supposed to. They were never supposed to have that function. And as I said, that's the beauty of having a democratic republic, that you're able to actually decide, hey, this is a state this is a locale that more closely aligns with my overall morality lines, rather than this other part of the country. It's a very big country.
It's not just the state. What ends up happening is you have forum shopping. You have it's not legal in Arizona, so you go to California. Do we want that as a society? Do we, over in Denver? Denver.
Yes, we do. Yes, we do. Because I like the culture in Michigan, despite the governor in the politics, But there's a Midwest culture, there's a Florida culture, there's a California culture, there's a prairie culture. People tend to gravitate towards the things that they like in the groups of people and the society that they like. Yes, everyone is different, and everyone needs to, if you call it forum shopping, or you could call it living somewhere or going somewhere that you feel more comfortable. It's a different societal arrangement in each one of these states. My wife is Swedish, and she always compares Sweden to the United States. And I said, the more appropriate analogy is Sweden to Michigan, because it's roughly the same size in population, demographics and landmass area. And I said, that's the more appropriate. You guys talk about, Europe is like the United States. So do you think, Sweden is different than France? That's different from Spain? Think of it that way. That's what the United States is. Everyone has a different culture in each state. And if the different rules and moral decisions come with that, that's what this system is supposed to be.
Amen.
Michael,
Amen.
Would you have any a last word on this, or?
No, I think I agree with Joe. I mean, my sensibilities are for smaller government, and I didn't mean to imply if I did, but I certainly
I
did
didn't
not
think you
mean
did.
to imply that any sort of affirmative obligation of the federal government. But the 21st Amendment being an abdication of the federal government to regulate how, like to tell states how to do it. They just said, coming out of Prohibition, we're repealing the 18th Amendment. There's an overwhelming demand for this in the country. States, you figure out how to deal with it ultimately. And I'm not even saying that Prohibition was bad per se, right? I'm not sure that it's worked or it hasn't, but I do think that we're arriving in a moment in American history where populist culture is shifting in a way that we don't really recognize from years past. I think we've got a sort of a neo-prohibitionist movement bubbling. And for that reason, I think we're sort of coming upon quickly a more religious revival or spiritual awakening. And I don't think that that's insignificant insofar as this conversation with abortion goes either. So I don't know. I just wanted to make sure that my position was clear. I'm 10th Amendment heavy. And then, even then, don't really like states having bureaucracies that are too large either. I just exist within a bureaucratic system that is very big and very systematized and tough to pierce for the average person.
I only have
Kind
a
of
couple
like
of minutes.
with the OJ dead discussion, we probably could go on for at least an hour and a half on this Arizona abortion issue. But I do want to move on to some of the other viral videos and stories that took place. And the next one we have
before you do that, before you jump, on to the next topic, if I can just cover something really quickly. I only have a few minutes left.
Okay.
Some of you may know, some of you may not know that I filed an action on behalf of my company, Good Logic LLC, and myself individually, under using an Article 78 proceeding, which is a special proceeding in the state of New York, where I am I'm suing Judge Juan Merchan, who's the judge in the Trump criminal action, on the basis that his order, which served to gag President Trump, is a violation of my rights of freedom of the press, because I'm unable to access him and I'm able to hear his take on things. And this is obviously, a matter of great import to the public at large, and that we're restricted from being able to access him. There actually is precedent in New York State to a case that goes back 35 years where the New York Times sued the judge who was overseeing the Joel Steinberg case and succeeded in getting the gag removed, because they said it is a violation of freedom of the press. So I feel very confident that I have standing to raise this claim, because I am recognized as a journalist I'm actually registered as a journalist with the city of New York. And this is a topic that I cover regularly, probably more than most people, with the possible exception of Robert Gouveia, he's there 24/7. But I'm covering this on a very, very frequent basis, and I can't access him. So I am now in the process. I actually notified Judge Merchan yesterday that today at 3:00 I'm making an application for a TRO to get a stay put into effect immediately on his order. That stay would basically say, okay, your order is on hold, and until it's resolved, Trump would be free, and either I win and it would be gone, or I lose and it would go back into effect. But the gag on Trump would be lifted. So procedurally, it's a very complicated thing as far as bouncing around. I have a docket number, but it's not uploaded in the computer system yet. I'm supposed to actually be getting on the phone back with the clerk, because they said the number should have been in the system. I don't think there's any nefarious intent behind it. I think this is just garden variety, confusion with the court system there. Everyone who's been talking to me has been very, very nice and trying to be very helpful. So I know people will naturally assume that this is some nefarious agenda by the court to skunk me. I would be shocked. And I'm not naive. Trust me. I would be shocked if that's the case. I think that I've seen this type of, confusion. Like, okay, you have a docket number, but there's different steps in the process. And when's the NICEP number, which is the computer filing number? When is that going to be eligible for you to actually upload systems? Because I can't upload my TRO, my request for this restraining order, into my docket until there's a portal, a place for me to actually upload it as part of my docket, as opposed to going to the whole general miscellaneous file that where anyone could file a digital submission to the court, and it's not going to be heard until it goes up under my docket. They actually told me before I should call back in 20 minutes because they said they're working hard to try and remedy the glitch that they're having with the computer system. So I'm probably going to be jumping in and out of here, and as soon as I get that, I'm going to be uploading those documents, and hopefully I'll be arguing this case. I don't know if that argument will be in person. I don't know if it'll be by Zoom. I don't know what it's going to be. But if you want more updates, I try to provide updates on my locals, which is goodlogic.locals.com. So anyone who wants more information on that, I urge you to check that out. So,
and Joe, what can we do as a group here, just hanging out, to help you? Is there anything we can do? Is it a monetary thing? Is it a
no.
Email?
I want you to look. I will tell you this: is it expensive to go through this? I mean, so far the printing costs alone were over $800. There's $300 for the filing fee. But I don't want anybody for a second to think that this is my way of making a pitch for money, because I've already been overcompensated for that by my audience, which has been very, very supportive of this application. So it's not like I'm not out of pocket here overall at all. If anything, quite the contrary. So I certainly don't want people to think like, oh my God, I need to help, support this. If you're interested in supporting it, I'm not going to complain, but no one should think for a second that it's like, oh, Joe's taking a financial bath on this, because it's just not the reality. So,
well, we certainly wouldn't presume that, because we trust you as an amazing commentator on YouTube and other platforms. But if there is anything we could do monetarily, what would we do?
So I have a Venmo, which is if people want to send money, I actually have to check. I always forget whether it's which
take your time. No worries. What about this? As you're finding that, anything we could do, like sending emails or somehow or snail mail, anything that we could do to help?
I would say I certainly don't see how emails would do anything right now. It's really not. It's really a question of whether the court's going to let me make my application, because unlike in Supreme Court, which is the lowest level court. So in Supreme Court, it's actually at Good Logic. That's what it is. It's my Venmo is at Good Logic. So
so everybody hears that it's at Good Logic. That's the Venmo,
LA, like it's spelled here, LAWGIC at Good Logic.
Perfect.
So thank you. So the I lost my train of thought. I was
you said the Supreme Court is the lowest court.
Yeah, the Supreme Court is the lowest court. If I bring a TRO application, a temporary restraining order application, on an emergency basis, and I check off all the right boxes, they must hear me. They might reject me, but at least I have an opportunity to present my argument, and I would literally go into court. I've done this dozens of times in a commercial setting. So, I gave an example like yesterday, and frequently you'll file a case, and at the same time you're filing it, you'll actually be bringing your TRO. You go into one clerk and you file, and then you go into a different clerk, which is motion support or ex parte, depending on which courthouse you're in. And the fascinating thing about this, as I was explaining to my audience last night, is that you actually notify your adversary, because you have to give them notice 24 hours in advance. And if you're filing a complaint at the same time that you're making your TRO application, so they heard the adversary heard about it the day before. The reason we do this is because in New York, certainly, and probably in most jurisdictions, they're very reluctant to give ex parte, meaning without the other side there, give ex parte relief. So, and they'd far prefer, instead of getting one side of the story. I think we're getting an echo from you, Norm. Good to see you. But I think we're getting
an echo.
Yeah.
This is that. Mike and I have had that problem. I don't know what to tell you. We've had it with a mic or without. Maybe I should just jump out and try to jump back in. Maybe that'll happen. Why
don't you do that, Norm? Thank you.
Yeah, and you could just mute until you have something to say. You know what I mean?
Hey, Mike, can you hear this? Let me check it.
I'm glad you did it upside down. Yes.
Right. So what I was trying to explain is that in the Supreme Court, your adversary hears about before anyone knows about it, because you have to give them 24-hour notice, because we far prefer having both sides there. It's obvious that if you have only one side presenting their side of the story and there's zero opposition, it's going to sound far more compelling than it perhaps should sound if you got to hear from the other side. So that's why unless there's some sort of, legitimate basis not to notify the other side, like, someone's life is going to be imperiled or physical health and safety will be imperiled, or there's literally no time because this is something that just happened, an hour ago and you need to get in there. We're pretty strict about following what's called Rule 202.7, where you give that 24-hour notice. That's why I went to court yesterday and served papers and gave notice to Judge Merchan. I actually walked into his courtroom and gave papers to his clerk. The appellate division clerk told me that they wanted me to serve Alvin Bragg also. So I served him with copies and a notice pursuant to Rule 202.7. I asked the clerk if I had to notify Trump also because, he's an interested party. We still got your echo there, brother. So I said, it sounds like crickets, if you're wondering. It sounds like it's sort of like nighttime and there's like a million crickets right outside your window. So basically, I asked them if I had to notify Trump, and they said it's all in his benefit. There's no harm to him, so he's not a necessary notice. But I tried notifying him. His office is obviously far too swamped now. They didn't even bother returning my call or my email. I haven't heard from them. I haven't heard from Todd Blanche at all. But yeah, so it's really not any better.
All right, I'm gonna bounce that. I'll see you guys next time.
Don't bounce. I just want everyone to know before you leave. This is Norm Pattis. He's an attorney who came on my channel, and when he came on there, I was talking about the idea of bringing this, and he actually said something that really resonated with me, which he said, if you don't bring this, and it's scary to bring it, but if you don't bring it, you're going to regret that for your rest of your life. And what I went through my brain at that moment was, I do not know if I will regret this for the rest of my life. But I do know that if I never grab these opportunities do not come along very often. And if I never grab any of them, that at the end of my life, I will regret not having done that. So now that I have this opportunity, I want to jump on this. So I want to thank you because what you said really resonated with me. And it was like a night, 24 hours later, I was laying in bed and I was like, F yeah, I'm doing this. I'm jumping in both feet. So
Lords of Chaos here. All right.
There you go. Anyway.
Well, Joe, I want to say thank you for describing that for us. If there's stuff that comes up, please let us all know as a community how we can help because we do, like you said, this is a once-in-a-lifetime opportunity. You should capitalize on it, and we want to help you because we're diehard fans. So
yeah, and it was Robert Barnes who first inspired the idea. He actually called me out on his stream, and he's like, Joe's a New York attorney. He's a member of the New York media. He's perfectly situated to do this, and that just got it germinating in my brain. And I was like, maybe I will. And I sort of was like, let me try getting a feel for how I would do this. And it just became stronger and stronger. And really, like I said, the idea started with Barnes, and it finished basically on inspiration that I drew from Norm Pattis. And I also want to just publicly call out Robert Gouveia, Ron Coleman, who spent hours. He actually helped edit my initial draft. It changed a lot of times since then, but he invested hours and spent an hour just motivating me to just push forward with this. So I want to the entire the law tube community, which is not really an association of people, but those who do what we do are law tubers, like what you do, Ian, what MLS does, Norm and Mike. What we're doing is what I call law tubing. We're explaining the law to the public through social media, and the people who have been covering this. And Viva Fry did a whole video on my filing yesterday, as did Robert Gouveia. Spent like an hour going line by line through my filings. So the encouragement and support from them has been phenomenal. I actually think this merits more attention, but I guess if I don't get heard by the court, I can understand why the public at large hasn't really heard anyone. And no, they haven't heard from anyone who didn't know me a week ago, reached out to me. Will that happen? It probably depends on whether or not the court hears me and what happens if and when they do. So that's where we're at right now. But yeah, if you want more updates, like I said, goodlogic.locals.com. I want to jump back in and see what I can do with the clerk to get that. What
about tracksuits? I keep hearing things about tracksuits. Do you need any new tracksuits?
There's all these jokes about whether or not it's my following. The show is called the Following Program.
I dressed the part today.
Right, whether or not it's a cult, and that's why I'm very clear every single day that the following is not at all a cult type of cult.
Just cult-like.
It's not at all a cult type of cult. So stop with all that. And there's no tracks, there's no spaceships, no self-harm, no harming others, no virgin sacrifices, no squirrel mutilations, no goat sacrifices, mild farm.
Oh, wait a minute. No squirrel mutilations. I'm out of here, guys. You know, I thought we were going to have.
I'm so glad that Norm piped up. I'm really excited that Norm is here,
Kool-Aid.
and I wanted to take advantage of his time because I know it's limited. We were going to talk, and we will get to it. We were going to go back to the OJ passing away, Norm, because I know you have some comments there. But I did have on my agenda some discussion about the Alex Jones FBI lawsuit.
Go do your things. I need to bounce, but you guys go do your things. Great
Take
seeing
care,
you
Joe.
all.
Hey,
All
Joe,
right,
I still want to talk about David and Bathsheba with you, you know? All right.
All right. Is he gone? Okay.
Yeah.
All right. Let's do this. I'm going to pause this for a moment. I want to shift gears to the Alex Jones FBI lawsuit. And Norm, just let us know if you can talk about this or not, but I thought you might have some interesting input on it. I'm going to put it on the screen here, and let's see if I can get it bigger.
And the FBI, we have to bring all this out. And right as my bankruptcy comes to a close, and then right as all this stuff's being finalized, it's really God working here that this came out at this time.
You just said you were planning on suing the federal government. What would a Alex Jones versus the U.S. government look like?
Well, I'm talking to different law firms right now that specialize in this. When I get off the feed with you, I'm going to get back on the phone with the lawyers. Obviously, a civil rights violation.
So let me pause it right there and just kind of give some context to this. This is a situation where midweek there is on caught behind camera, a purported CIA agent who kind of admitted that the Alex Jones civil lawsuits for defamation were the product of, were influenced by, they use the word nudge, the federal government. And so what Alex Jones, once he saw this video, his first thought was, shoot, I better figure out some way to, file in 1983 a civil rights action to be able to, one, get discovery on this particular case, and then two, perhaps maybe even get some damages. Norm, do you have any involvement in this or any?
I have no involvement in it. I continue to represent Alex in connection with his appeal of the defamation verdict in Connecticut incident to Sandy Hook. And I've not spoken to he or anybody in his camp about it. But in terms of 1983 litigation, that's how I came up as a young lawyer. I spent 10, 15 years. I had a case in front of the U.S. Supreme Court on 1983 stuff. And so the state action, 1983, 42 United States Code, Section 1983, part of the Civil Rights Era Act, of the World War II Reconstruction cases, that basically says when a person's rights are violated, federal constitutional rights are violated by an individual, they can bring an action for money damages. And there's a whole complex body of law that arises out of that. The one piece I want to focus on now is the so-called state action requirement. And so if the state or somebody acting under color of law intentionally violates your constitutional rights, you can bring an action for money damages. So question, what do we know? The video you showed, I don't think was of a CIA agent. I think it was a contract employee who came in at a relatively low GS level, and it's not likely that he was an operations officer. What do I know about operations officers? I was once vetted to be one years ago when I was in college. We went through the interview process, and I knew what it was going to take. And in the end, they had reservations about me and didn't hire me, and that's probably all for the best. But an operations officer is a person who acts undercover, who acts to surreptitiously achieve the objectives of the United States. Under federal law, CIA agents are not supposed to operate in the United States. They do. I mean, I'm aware that there are agents active in the United States monitoring immigration, monitoring the formation of terrorist cells by immigrants. Now, does that sound paranoid? Yes, it does, but it actually is true. With respect to this fellow who appears to be on a first date at a coffee shop, I wouldn't buy a share of the Brooklyn Bridge from this guy if he offered it to me for 12 cents. I'd feel like I got ripped off. This to me looks like bluster, and it doesn't make any sense. What did the CIA want? The CIA wanted, they wanted Jones's money. Well, they didn't get it. What did they want? Did they want to silence him? Well, they didn't, and you never will. So Jones will continue to talk. And then he gets basic facts wrong. It wasn't $100 million judgment. It was a $1.5 billion judgment. So for a man who claims to be part of the so-called deep state operation, nudging private plaintiffs along to silence a critic of the deep state, the man is remarkably ineffective and doesn't know anything. And so to me, it looked like I'm glad I'm not dating, because if this is what you get on a first date, and what you're going to get is the retreads from social media as your talking points, how are you ever going to come to trust the person and have a heart-to-heart relationship with them? You know,
It was an interesting video. At the beginning, the CIA related person, contracting officer, couldn't remember Alex Jones's name. So you're right. It almost was like he was trying to bluster in order to further the date, so to speak.
Well, you know, the Alex Jones, the energy associated with Alex Jones in social media and in society is so much larger than life. I've got two very fun anecdotes about them. You know, I've been tainted by Alex Jones in the case. If you look at me on social media, I'm Alex Jones's lawyer. You know, if I fart in a public place, it's going to be Alex Jones' lawyer commits EPA violation. You know, and this is just not a fun place to be. So, you know, I'm picking a jury 2 towns over last week from where Sandy Hook. And the judge says do any of you recognize any of the participants in the case? And we have individual voir dire where we question jurors one at a time. So the first guy says, yeah, I recognize him, pointing at me. It's my turn to question. I said, how do you recognize me? Oh, you're all over the news. You know, you had so-and-so's case, such and such a case, and you were Alex Jones's lawyer. They're like, okay. So I look at him and I say, would it surprise you to learn that I have received thousands of pieces of hate mail as a result of my involvement with the Alex Jones case? The guy looks at me for a moment. No. So then I say, did you send any of them? and no, I didn't. But you probably would agree with some of the sentiments, wouldn't you? And then I took the risk and I said, would it surprise you to learn that I'm just like every other guy doing his job who wants nothing other than to be loved and to love in return? And he looked at me differently and it broke the haze. Then, and this, you can't make this up. The other day, I was heading back to that same courthouse to argue motions. It was yesterday, in fact, and I was running late for one reason or another. Traffic was bad. I looked at my gas tank, and I had 50 miles to go. So I thought, well, I'll get close and I'll find a station. I got distracted, and as the tank ran empty, I was 1 town from Newtown, where Sandy Hook is. So I got off where there was a gas sign, followed it to the end of the road, and there was no gas station. So I went into Newtown, you know, where I've never I would be careful eating in a deli for fear of what they might put in the sandwich. And I thought, I'm going to run out of gas in Newtown, where I'm Alex Jones's lawyer. So what am I going to do? You know, I looked around for a gas station and I couldn't find one. So I walked into Town Hall, a site of a lot of toxicity, and I said, hi. I did, and I just kept quiet. I didn't say I'm Alex Jones's lawyer. Where is it this point? I'm not Alex Jones's lawyer. I mean, I am in court, but in real life, in flesh and blood, I was a guy who needed gas. And so rather than having that social media filter, color the perception of who I was, I just walked up to somebody and said, look, I screwed up. I'm out of gas. I need it in a hurry. And they told me where to go. So the point is, I got out from under the Alex Jones fumes and was able to cut through it and make human contact, both with a jury and people in the town hall in Utah. This guy in social media looks like he's just repeating what he read. And you kind of wonder whether anybody can get through all that noise to the bleeding heart between them. And it makes me worry about the impact of social media on human intimacy, because if you're going to make love to an avatar, don't complain if it's 2-dimensional sex. I mean, you know, there are real people out there. And we're not, yeah, I know. You're thinking, hey, what's wrong with 2-dimensional is better than none at all. I don't know about that. I really, and honestly don't know about that, you know.
Norm, what about this? And also, let's Michael and obviously Dave chime in. What about the power of discovery? Is this kind of the foothold that Alex Jones needs now to bring an action against the federal government and then draw out any connections that there were? You know, there seems to be the allegation that, because Alex Jones talks later in the video about how he was at mediations and there were some sort of his family and him were influenced by government agents. If he's able to subpoena and he's able to get people on the record on deposition or interrogatories or something like that about any governmental involvement in the defamation cases, wouldn't that just be a complete boon? It would just blow up on social media, and maybe he could get some relief out of it.
I love Alex.
Sorry, I was just when this case, I didn't know about this until this morning when our agenda was sent out and I was given homework. And but I was looking into it, and there's a case. If you guys remember, 3 Americans were targeted and killed with a drone in 2011 in Yemen. There's a lawsuit that stemmed from that. And it was a Bevins cause of action, which is essentially the 1983 sort of thing. But it's I'm going to spell it AULAQI v. Pineda. And the argument is that by the government's actions, killing essentially 3 U.S. citizens, they were deprived of their due process rights. And it goes through a very similar analysis that I would suspect Alex Jones would have with this sort of thing. And I think based off of this, plus the Reagan case involving Contra and Bevins itself, I don't know if they'd get to discovery, because I think the very first thing would be a summary to dismiss, and it's probably going to be granted. Now, I do believe that this case might set up some sort of framework that Alex could use to maybe try to get around some of this, but he'd have to be very careful to do it the right way to survive an immediate summary disposition motion, so that he could actually even get into discovery.
I think that's right. I think that he, so the lead case, so in federal court, every action begins with a complaint, and a complaint under Rule 8 is a short and plain statement of the facts of civil procedure that provide the other side with notice of the facts on which you rely on your claims for relief. And federal courts operate under what's called notice pleading versus fact pleading. In other words, you don't have to plead chapter and verse. You just have to give a short, plain statement. However, the United States Supreme Court doesn't want people to just make stuff up or to give conclusory statements. You have to plead sufficient facts. And so under Iqbal, IQBAL versus Twombly, TWOMBLEY, under Iqbal versus Twombly, you have to plead credible facts. And to my mind, there is nothing credible and factual in what that internet chatterbox had to say that would survive a motion to dismiss. So this case never advances to discovery, and the notion that somehow there's a lot of internet buzz about CIs, confidential informants, confidential human sources associated with the FBI in the January 6th meltdown. I know a lot about that. I tried the Proud Boys case with several other lawyers, 5.5 months trial. I've been given books of information, or a book of information about CIs on the ground that day, and have been ordered to keep it confidential. There's something there. The law enforcement had eyes and ears on the ground, but I'm unaware personally of credible evidence that law enforcement provoked this. They may not have stopped it. They may have egged people on from time to time. They may have even participated. But for my money and my involvement, this was a spontaneous event.
I've got a question for the three of you. And Norm, you and I spoke about this briefly, but I made sure to surface this on the stream when we talked about it. My initial questions here: what is Sound Investigations? Soundinvestigations.com, right, is the source of this video, this undercover video, but it made its way into my social timeline by and through the Daily Wire, right? And so I think that getting to my question, what risk is presented to Sound Investigations if this video that we're talking about that Alex is using to kind of snowball into this, there's nothing there. If you go to the website, I think the earliest video you come to is from September of 23. It doesn't have an about section. It doesn't identify any sources or anybody that runs the organization. I know very little about it. I found very little about it. Admittedly, I didn't go on a deep dive like I would anything else. However, it's not, I assumed at first glance that this was something that was like James O'Keefe related, just because of the way
me too,
and whatever. It wasn't until I actually looked at the source at Sound Investigation. So I think that to to kind of steel man the government's argument here, it's you got to show a little bit more than, sound investigations, undercover video. Was to say that this is legitimate. Sure, this guy may be verified on LinkedIn as saying that he is a contracting officer with the CIA, but what gives him any specific credibility, and what gives this video any specific credibility in terms of being an undercover sort of making statements against interest or whatever else, right?
Well, the only thing I saw is I listened to a James O'Keefe space on X, and he was indicating that he knew the people, I don't remember the names, behind sound investigations. And I think, and the comments can correct me, he was a previous employee to O'Keefe's organization that went on to start doing this type of stuff. And he was praising sound investigations as another new independent journalist that was going to be able to get these undercover type investigations. That's what I listened to from James O'Keefe.
Well, and I guess my question is sort of ultimately, is this going to be an unmasking of whatever sound investigations ultimately is, and is that something that sound investigations ultimately is ready to withstand, right? Is that sort of scrutiny that is prepared to withstand?
Yeah. It's an interesting case. I'm so glad that we had Norm here because the fact that you previously represented him, and we'll see what happens. I hear the argument about discovery not even taking place. But I also, oftentimes, I think you can get subpoenas even pre-complaint in some situations. So there may be some power that's, that comes from this to be able to just uncover what really went on here. It's more than just what you watch on the documentary. While we have a little bit more time, can we switch gears? I wanted to talk a little bit about one of the topics that really kind of went off this week. And this was the
it went off. Yeah, a lot went off.
Yeah, this is the Dexter Reed incident. We really can't spend a lot of time on the images because they are very very sensitive. I made a video on it today or yesterday, and it was difficult. It got censored and taken down. So the point of it is this is a situation where we have a traffic stop in Chicago in a neighborhood. Let's be real clear about it. We have two individuals in a white SUV vehicle, and I guess it's playing. I'll stop it right now.
We don't hear it.
Sorry about that. Oh, okay, great. And we have a stop by undercover officers. The justification that's alleged in the media, could be wrong, is not wearing a seatbelt. We have a plainclothes officer approach the driver's side window. It's rolled down. Please exit the vehicle. Then we have a gun drawn, and then we have. I'm going to try to use very kind of ambiguous words. Then we have fire from the driver at the police, and then we have allegedly 96 shots into the vehicle, where the driver obviously has passed away, Dexter Reed, and then also his passenger was substantially injured. I think when I made this video,
we have an officer that's been shot as well. Am I correct in that, or was that an assumption? Because that's what I heard in the video.
From what I understand, and please correct me if I missed this, no officer was injured as a result of the fire back. It was merely shot at the officer, and again, allegedly. And that's why it's great to have Norm here as a renowned defense attorney. But the point of it is that
renowned.
The controversy.
Better to be renowned than reverbed, right?
Yeah. The controversy is not so much probable cause, even though you could argue wearing a seatbelt for this, not so much that. And it's also not so much use of deadly force, because allegedly we have this driver firing and then, a legitimate response by the police officers. The question I got a lot of guff for it was 100 or 96 shots in a neighborhood. Do you guys have any thoughts on that?
Well, it's not so much for me, it's not so much the number of shots, because you shoot. Hey, there he is. See, he's going to have all the answers, Runkle is. But it's not so much the number of shots, because you shoot until the threat is gone, right? It's the fact that there's a neighborhood behind them, and that the officers live in the action said, watch out for the neighbors, make sure you cover the neighbors. No, for my understanding, none of the neighbors were hit. And so that's a good thing. But even if they were, we're talking about maybe civil action against a neighbor that was shot in this thing. The officers are cognizant, are they're aware of what's behind them and that there's neighbors there. And so the question is, did they act reasonable within the circumstances? I don't see it being, I mean, it sounds scary to the layman, 96 shots, all this going off neighborhood around. But am I just sort of one time watching it? I feel like it was fairly reasonable. Although I will say I hate the idea of unmarked officers, unmarked cars doing anything with the public.
I mean, I've done a lot of police death shooting cases. In fact, we're likely to file one next week. We were contacted this week by a family, and so, a police shooting is evaluated from the perspective of 42 U.S.C. 1983 under the Fourth Amendment, and the question is it a reasonable seizure of a person? That's the standard, and it's a so-called objective standard. Would a reasonable officer in this position of those who fired fire, and they have a right to, and the state, according to Max Weber, great German sociologist, basically says I'm looking at the comments, basically said that the state has a monopoly on the legitimate use of force. So officers have a right to kill. And the question is, under what circumstances can they exercise that right? Typically, if they believe that their lives are in imminent risk of serious physical harm, or the life of a third party is. So, you stop, you talk to someone, they reach for a gun, they fire at you. They're going to shoot back. Furtive movements are other cases in which officers shoot. A person makes an abrupt note. That's why whenever I get stopped for a cell phone violation, which I do from time to time, my hands are 10 and 2 on the wheel. I ask permission to move my hands because I'm not going to give anybody an excuse to blow me away. By the way, on the topic of being blown away, how do you know you've been married too long? Your wife's idea of oral sex is sending you a letter bomb. You get blown away. But in any case, the number of shots doesn't surprise me. The fact that it was done in a residential area, if somebody had been hit by a stray bullet or a ricochet.
Norm, can I pause you right there? Norm, why does that not surprise you?
Were there five
shots would have been more than enough.
It would have been, but how do you know in the moment?
Yeah,
how do you know?
You shoot 5 times, you wait. If there's any movement, you either shoot or not.
When your life is on the line, you're going to shoot 5 times and give the person an opportunity. I'm going to empty my clip and make sure that MF isn't going to shoot back.
If you watch the video, he's sitting there and he's in a vehicle with very strong tint. You can't see the guy. I'm just going to correct the reports I saw says that one officer was hit in the arm. So you can't see him. And I'm just going to say the other thing. Police officers are notoriously bad shots. It would not have surprised me to hear this many shots fired and the guy lives. But you can't just what's the reassess is you fire 5 shots and then, oh wait, he's still alive. He's now lined up and popped, an officer in the head.
But Ian, so is it 200 shots? I mean,
it's whatever it takes. It's what it takes. And the thing is that if somebody was breaking into my house, I'm not necessarily firing, 2 shots waiting. I'm firing until the threat has stopped.
I want to counter real quick.
What if you had a grenade launcher? I'm getting kind of stupid here, but my point is that it seems to be that cops these days, again, I understand there's no question about the probable cause, the use of deadly force, no question, but we're in a residential neighborhood. Does it make sense to launch 100 bullets or 96 bullets, in a residential neighborhood? I don't know.
I mean, the problem I have with this takedown is that the takedown itself was extremely badly planned from my look at things. They have undercover officers with plain clothes, which creates the real, let's consider the alternate hypothetical that this guy lives. There's actually the possibility that he could walk on the shooting of the officer because it's I thought that these were a bunch of guys trying to murder me.
Well, that is
because
true.
They're in plain clothes, and I mean, they really should have followed this guy. They should have been. They can have the unmarked car, but have some, have it clear that it's police officers, and then they say that this was a seatbelt stop. This was not a seatbelt. I mean, it's pretextually a seatbelt stop, but that they were targeting this guy. That there was a reason.
The first criminal trial that I tried in Connecticut after 9/11 involved the police ambush of a kid, Akoff Ortiz, in a meadow in Connecticut. So Akoff was an aspiring young drug dealer. He needed capital, so he did the only thing reasonable under the circumstances. He robbed his girlfriend's father's gun collection. The girlfriend's father happened to be a state trooper, so people were upset. They go looking for Akoff. So his accomplice ends up dead in the wood. Akoff is gone for a year. When he returns to Connecticut, word is he's back, and the police want to get him, but they figure he's a dangerous guy. So they arrange for him to meet his girlfriend at his house in some location. And then there's a small meadow and a creek, and you cross over a bridge to get to the girl's house. So they lay in wait for him there in the dead of night, around midnight, in dark raid uniforms with police written on the back. And Akoff was armed. He walked across the bridge, and they jumped out and started to holler police, and he shot back at the cops. And so he was charged with attempted murder of police officers. And to the point about unmarked police officers undercover, our defense was he had been attacked, he was shocked, it was reasonable self-defense for him to shoot, and he was acquitted of those charges, convicted of many others. So I think jurors are open to that. But because every courtroom story has to be humorous, at least in my life. Here's the best part of that trial. Before we got the acquittal, I was laying the raid uniform out, on the floor of the jury, so the jury could see just how from the front you couldn't tell it was a cop. And as I bent over to adjust something, you heard this loud crack in the courtroom, and I unfortunately had passed gas. And if there's one thing you don't want to do in a jury's presence, it's fart loudly. So there was this shock in the room, and I turned and I said, "Yes, I passed gas. Please forgive me." And everybody laughed. So a little bit of honesty goes a long way. But the bottom line is that is a valid defense, and it's a great point. And he may well have had a good defense, and it's awkward. I mean, police have a responsibility to notify people, it seems to me, before they shoot. And it may be. I don't think a civil action against the cops on behalf of the decedent will go very far in this instance, but I can see why they might want to try.
I wanted
to say another way.
Does anybody remember Tyree Nichols in Memphis and the unit of police officers that were plainclothes? They were in unmarked cars. Norm, you and I talked about this. God, this has been back early 2023. But I think that the question that you asked, Ian, I think was being answered from a perspective of attorneys and practitioners that understand law enforcement engagement with suspects that are when they are in plain clothes and when suspects can pretty obviously identify that they are being seized of their freedom of movement, right, by a presumed lawful authority. I think policing is shifting in a way that I don't really have confidence speaking on right now, because if what was going on in Memphis by and through the creation of these sort of guerrilla style squads of officers that are moving about and they're trying to actually blend in with the environment, wearing hoodies and whatnot. And these are sort of like standard issue in terms of the way they're moving. If there's any aspect of that happening in a place like Chicago, right, which is, shares some violent upticks in the same way that Memphis does, then I think the analysis is certainly bound to change, right? The rules of engagement have shifted, and I don't know that I can say much more than that confidently, but sorry to cut you off.
No, I was just going to say, but imagine if those plainclothes officers were in fact not plainclothes officers, but in fact someone who wanted to unalive him, and he shot first. He might have a valid self-defense, right? And it's not like, we could go all the way back to the Valentine's Day massacre in Chicago, and with criminals posing as cops to off their competitors. So I don't like the plainclothes idea at all. Period. I agree with Runkle that the whole apprehension was flawed from the start. But Ian's issue that he presented to us is 96 shots in a residential neighborhood. I don't find that to be terribly nothing wrong with that. Again, you shoot until the threat is gone. Now, I will say this too. It was like 5 officers that I think I saw. It might have been more, but if it's 5, it's 20 shots each. It's not, it's not like all of them shot 96 shots.
It's like less than 30 seconds. They're firing. And then by the time they have like a chance to reassess, it's been 96 shots because each officer is responding to it. It's not really, a surprise there, but I see parallels. There's a couple of cases here in Canada. One is Basil Parasiris. They raided his house. They had they had outfits that had police on them on the back. And this guy, as they're raiding his house, they shot into his kid's bedroom. His kids were screaming. He retrieves a gun because here in Canada, everything's got to be in locked boxes, but he retrieves it. First officer comes in and he puts one in the head, one in the chest, and the officer dies. And he shoots at the second officer before noticing that the first guy who's fallen down has police on his back. He's acquitted. He walks. Right now, we've got the case of Umar Zamir, who was similar thing. He's sitting in his vehicle. The police run up to him. They're not in uniform. They're in plain clothes. He freaks out. He doesn't know what's going on, slams it in reverse, and backs over a police officer. And that trial is ongoing right now, but there's a very good chance he gets acquitted on that. I am concerned when I see police doing this because it creates this possibility of people, legitimately shooting back and legitimately, using force or just trying to get away. Because what do you do if you see a bunch of people in just ordinary clothing running up on you with guns?
Yeah, it's just a whole bad situation to begin with. That's kind of what it boils down to for me. And that was when I was watching the video, I didn't realize that they were undercover officers doing any sort of sting. By the way, can we just make it a rule that undercover officers shall not stop a vehicle for a traffic violation? How about that?
That's actually a great point.
Well,
that's really you say it smiling, but why not? I mean, because the potential for this going, the wheels coming off the apple cart is so great. That's a great idea.
Yeah, and that's the idea. That's the idea. The reason I reference, Tyree Nichols is not that that was a shooting. If we recall, that was, this wild series of beatings of a suspect that they had in custody against the police car. They were taking turns, like kicking him in the head and all sorts of wild stuff. But that group of police officers were a part of some sort of task force that was subsequently disbanded. But the thing that struck me in reviewing the videos then was the fact that these guys are aggressively pursuing a suspect, and they're all a part of this task force where they're wearing hoodies and BDUs and combat boots, and there's no obvious signs that they are acting under the color of law, under the color of a badge. So not to give any undue defense or credit to the deceased in this case, but the point here is that if we want a well-functioning society, if we want a system of laws and justice, and we want citizens to act in accordance with those laws, it must be obvious when they are being seized by a lawful authority. Now, again, I could be giving argument and credibility that is undue and undeserved in this case, but I think principally we can agree that we should not feel as though we just have to be seized when somebody begins to exert force without some sort of obvious brand that we should see as legitimate.
Well, I think this is a good discussion. The only thing I have to say is, and I love, there was one comment that talked about the fact that they said, why are we even talking about this? No neighbors were injured. So 196 shots went off. What's the big deal? And I guess that's right. I mean, I guess that's how we go forward, is that there could be arguably excessive or over exuberance on behalf of our law enforcement if nothing happens other than what should have happened, which is someone's being, they're shooting, a suspect is shooting at them. We just move on. But at some point in time, someone is going to get injured, and we're going to have to evaluate law enforcement standards for how they use their deadly force with respect to the magnitude of the deadly force. And that's my only point.
The only thing I want to say about that is probably for another day is that when the police, though, use 96 shots to stop a suspect, and then they charge, say, Travis Rudolph and his brother because they shot too many times, I have a problem with this sort of double standard, but that's probably for another day.
Ian?
The other thing is, if there's not going to be any reckoning, because let's say the guy survived and the police miss, but in the course of this shooting, they hit a nun, they hit like a playground, they hit 12, they kill 12 people, all of whom aren't the suspect. They just put all those deaths on the guy they were shooting at. So it's not like, there's no possibility for these officers to really face any sort of accountability or anything like that. It's going to keep happening. But the flip side of that is that, you know, if I was walking down the street and let's say it was legal to carry a firearm here, if somebody was like came up and started shooting at me, they may have a fair bit of forgiveness if I didn't have full understanding of my background on that. So,
Right.
This comment's really interesting to me, but I think it's also speaking to the larger point because many people in the chat are talking about, and I think it was already said on this panel,
really?
the inaccuracy of firearms and discharge of firearms by law enforcement officers. But this is one of the foundational issues that we're seeing now is that the incentive structure for policing has completely changed, right? The recruitment crisis is indeed a crisis all over the country. Your local departments, wherever you are in the country viewing this right now, you should do some homework and see how many vacancies there are in your local department and understand that cities and municipalities are struggling to find. And then once they get applicants to go into training, right, they are even more incentivized to get them through all the way to becoming a commissioned officer by any means necessary. If that means sending them back through firearms training and whatever 4, 5, 6, 7 times until they pass fairly, that's what it takes right now, and that's kind of the product that's being put out into the street. So this is a real problem.
Hey, so I know I was late to the game today, but did you guys already talk about OJ?
Well, you know, it's funny. I was going to bring that right back up. We do have 5 minutes left. So, Norm, do you have some stories about OJ?
A little bit, yeah. So I've been very lucky in life to have attracted the attention of good lawyers who've worked with me, including F. Lee Bailey. Spent a year or so hanging around with him, guest in his home. We worked cases up and down the East Coast and spent many hours over bottles of various libations talking about his cases, including OJ Simpson. So I was at his house once in Brookline, Massachusetts. I can't remember what we were doing. He had been disbarred at this point. So he'd get a case and I'd bring, and we were helping some guy out up and down the East Coast. I'm in a study in his house one day and he'd knock at the door. It's about 10 a.m. There's Lee with a big brown bottle. I mean, a big glass of something brown. He says, "You want a drink?" I said, "Lee, I don't touch anything till at least 8 o'clock at night. I'm one done." "Alcohol is my fuel," he said. And so we talked. And we talked about OJ and his view. He was 100% certain in his view that OJ was innocent. And he tells an interesting story about the defense team, which was led by Johnny Cochran, rushing to get its case through because Lancito had so messed up the case, they were losing jurors. And they were worried about falling below 12 and having a mistrial. So they didn't present some evidence, which included a guy who looked a lot like OJ being present at or near the scene. So I always appreciated that story from Lee. He got himself in some trouble with the tax authorities. Ultimately, did a book after a bankruptcy was closed and tax liens forgiven and whatnot. And I don't remember the book, but I know Mike and I interviewed Lee a few years ago on law and legitimacy. Maybe Mike can get you a link. But for what it's worth,
the book is called "The Truth About the O.J. Simpson Trial" by the architect of the defense. That's F. Lee Bailey.
And Bailey. He had promised me that I'd get an invitation to his 100th birthday party. He welched by dying at 88. So that's a party I won't get to go to. But I can tell you that of all the lawyers that I've met, and I've met a lot in the course of a long career, he was the best fact trier I ever knew. He had an amazing ability to immerse himself in a file and just know things. And so he was a resource to our firm. He was also involved with the American Polygraphic Society. We used to take people up to his place for polygraph exams because they wanted to challenge the admissibility of polygraph exams in criminal cases. Unfortunately, my clients kept flunking them, and therefore we didn't have the right predicate. But just a brilliant, generous man. I miss him, and his perspective on OJ always startled me because I thought, wow, there's motive aplenty there for OJ, given the rage that jealousy can inspire. But it reminds me that in a circumstantial case, powerful motives can frankly turn a case in spite of physical evidence. And so in Lee's case, OJ was innocent. And I think people tuning in, wondering about this in the wake of OJ's death should hear it. And now they have.
I was going to ask you, Norm, did F. Lee Bailey ever give you an insight into OJ, the person? I mean, we had a long discussion at the beginning of our session today about the magnetism of his personality. It was pretty much the first public glimpse. I shouldn't say first, but one of the, in recent memory, a glimpse of a courtroom, especially LA Superior Court, and how it works. Did he have any perspective on working with OJ, and was he forthcoming? Anything like that?
It's interesting. I mean, the questions you could ask. What a great question that would have been to ask if only I had thought about it. He was not the lead lawyer in the team. That was a highly contentious group of lawyers.
Yes.
His job was primarily to unearth the Furman stuff, and he did it with his masterful cross-examination of Furman on the N-word. Yes. I think the case came through Kardashian rather than it went to Cochran. And I think Lee was always an invited guest to the party. And, as a very charismatic and well-known lawyer, it's sometimes hard to make a team. Cochran was number one. Lee could have been perceived as taken over. And so I think when I've been part of a defense team, if I've been brought in, you always defer to lead counsel, and you make that a mantra, because there's no right way to try a case. There are wrong ways. And, a good lawyer will police the standard of care, but respect the differences among his colleagues. And so in a case with lead counsel, you don't want to mess up Picasso's brushstrokes. He's not there painting a Rembrandt. He's doing his thing. And so the primary relationship was between, Cochran and Simpson. I don't recall Lee saying anything about it. And frankly, I wasn't smart enough to ask.
Okay. Well, guys, I promised Eric that I would make this a firm hour and a half because we all have cases to try, so to speak. But I wanted to give an opportunity of everyone who donated their time. And thank you so much, lawyers, for donating your time. It's some of you are charging many hundreds, maybe thousands of dollars an hour. And we're so grateful that you're here. And so I wanted to give you a chance to give us an update on what you're doing, what your channels are, what your socials are. So all the people out there can come out and follow you, watch your stuff, because it's great stuff. Dave, do you have anything on that?
My channel is about to be shut down. Was Making Law Simple. And due to some copyright claims, which I believe are fraudulent, YouTube has said that they're giving me on the 15th, my channel will be shut down. But I have a new channel. Actually, I have a couple of them, but it's MLS God of Law, and then I also have Lego Law. So 2 new channels. Come check them out. I've been doing a lot of stuff with the Zachariah Anderson trial. I've been doing some recaps with Zachariah Anderson's brother. If you don't know that case, it was from last year. I believe Zachariah Anderson was wrongfully convicted out of Kenosha, Wisconsin. Not because he might be innocent, but because there definitely wasn't enough evidence, and the trial tactics from the prosecutor were just abhorrent. So come check me out over there.
Dave, I just wanted to say to everyone else out there, follow him in his new channels. What I love about him, I love talking when we do our Friday shows, is his outside the box thinking. There's been plenty of times that I've had this firm position in the law, and then I speak to MLS and he's like, "Oh no, did you think about this?" I'm like, "Oh shoot, I didn't." So anyway, follow him out there. Michael, do you have any things for us? Any socials that you want to follow?
Yeah, just LawPod Daily. Norm and I stream every morning at 8 a.m. Monday through Friday on YouTube, X, and on Rumble. You can find us. Law and Legitimacy is the full brand. LawPod Daily is the handle. And we've been talking this week about the Joe Houston stuff out of Las Vegas, the attorney that shot his former daughter-in-law and her spouse, both attorneys, and then turned the gun on himself over. And so just within the legal community, we find that significant. We've been talking about that, kind of tracking that. And then, Norm shared some good stuff this morning regarding OJ, but we talked about the Arizona abortion issue as well. So if you could give us a follow over there, we're here on YouTube as well. And thanks to this platform, Laid Back Law, we finally got over the 1,000 threshold, and we're part of the partner program. So thank you to all of you that come here every Friday. Cannot extend enough gratitude to all of you for being here. So thank you.
Thank you. Right, by the way, Mike, I just wanted to say I changed my name to my actual new YouTube channel so you guys can see it.
Yeah, so everybody go follow that at YouTube. And thanks, Mike. We really appreciate it. I can't wait to tune in and talk some legal issues with you and Norm. Norm, do you have anything that we should be aware of coming up that we should follow you for?
No, I mean, I was getting ready to try a significant fraud case, a so-called black money fraud case. But, beware of those emails that say we've got money we want to give you. My uncle's a Nigerian prince, that kind of thing. But events have blown up in that case. And I was late to the stream this morning because the events have blown up in such a significant way that we filed a motion to withdraw after some emergency ex parte discussions, and I don't know if that trial is going to go forward. Can't say more except to say that in the law, as Thomas Hobbes once said, life is nasty, poor, solitary, brutish, and short. Stay tuned, because you never know what's going to happen in the state of nature. You know?
Well said. Thanks, Norm. Thank you so much again for your time. And Ian, Runkle of the Bailey, is there anything that we should be following you for? Something coming up that's interesting?
Right now, I'm going to be up. There's a case out in Ontario where a store clerk was attacked by a guy with a bat. He manages to get the bat away from him, and now is facing charges that have a max of 14 years. He's not going to be getting 14 years, but I've got a video looking at the video surveillance of that, and I'm going to be talking a little bit imminently about Umar Zamir, that case that I mentioned of the guy who panics and ends up killing a police officer. So it's a weird world. Also, if you're interested in Jeanette Braun, who's a lawyer who is behaving hilariously with copyright takedowns. So I guess there's a bit of a parallel between that and what MG Law is going through. So
John Forsyth is quite the wit. Life is like Joe Rogan, nasty, brutish, and short.
Joe Rogan's not poor, though.
Yeah.
Got that part.
Well, guys, thanks again. I'm Ian Corzine, and you can follow me on YouTube, TikTok, Instagram at Ian Corzine. Thank you again for joining us. Thank you to all the lawyers. We really appreciate your time here. And next week, you're going to have the real great host, Eric Hunley. He'll be hosting a number of us lawyers with a lot more issues to talk about. And I'm excited to either be there or watch. So again, guys, have a wonderful day. Have a good weekend.
Ciao.
Bye.